Formal parts of a deed. A deed may be divided into the following parts. 1. Introductory part, which includes a commencement. The nature of the transaction determines the commencement. Assignment, this deed of assignment. For a mortgage, this deed of legal mortgage. B. Date. A deed takes effect from the date of its delivery and not on the date on which it is therein stated to have been made or executed. This Section 157 Evidence Act and Local and Standard Bank. When drafting, it is better to leave the deed undated. There are three reasons why a deed is drafted without the date. 1. Section 157 Evidence Act already provides for the rebuttable presumption as to the date of a document, and as such, failure to include the date is not fatal. 2. Section 23 sub 2A and 23 sub 4 Stamp Duties Act provides that unless an instrument is written upon duly stamped material, it shall be duly stamped with the proper ad valorem duty within 30 days from the day it was executed or after it was shipped into Nigeria, if it was executed outside Nigeria. Therefore, because of the time limit prescribed for payment of stamp duties, conveyancers usually omit the date on the deed in order to avoid being in default and to avoid the penalty that follows. 3. The land instrument registration laws provide for registration within 60 days from the date of execution. Failure to do so attracts penalty. C. The parties. A party to a deed must be legal persons. This consists of natural persons and entities with corporate personality. A party to the deed must also be described in detail. This includes the name, address, and status in the contract in bracket. The description of the parties as to status is dependent on the nature of the transaction. For example, this deed of assignment is made this dash day of dash 20 between Chipemeka and Laja itself, number 64 Ikeja Street, Ikeja, Lagos, as signer of the one part, and Ogo David of number 17 Ude Street, Suru Alaba, Lagos, as signer of the other part. Section 58 sub to Conveyancing Act 1881 deems covenants to be made with the covenantee and his successors in title and those deriving interest under him or her. In drafting, always indicate the status of the parties. Note also that if you choose to use of the one part, it goes with of the other part, and if you choose to use of the first part, it goes with of the second part. D. Recitals. These are precise and clear statements of the material facts constituting the background to the present transaction and stated in a chronological order which explains the reasons for the transaction. Nitel and Rococo. The existence of recitals in a deed is determined by the word is used in the commencement. Recitals generally start with the word whereas, no matter the number of paragraphs. Recitals can be introductory or narrative. A narrative recital usually comes before the introductory recital and it states the root of title and the property up till the person in whom it is currently vested, i.e., it narrates the history of how the vendor came to own the property in question. An introductory recital usually comes below the narrative recital and it explains the vendor's intention to transfer the property to the purchaser and purchaser's intention to acquire the property from the vendor. If a defect in title is mentioned in a recital, a remedy for it should also be stated. For example, if it is this deed of assignment is, then a recital will be inserted. If it is this deed of assignment made this dash day of dash, then there will be no recital. Functions of a recital. 1. A clear recital can help clear ambiguity in the main body of the document. 2. Section 162 of the Evidence Act provides that when there is recital of fact in the document that is 20 years old at the date of the contract, it will be taken to be sufficient proof of title. Thus, the statements of facts in such a recital are presumed to be true and correct. This is the ancient document rule. 3. Statement of facts in a recital may give rise to estoppel against the person making them. Section 169 Evidence Act 2011. Ulukoya and Ashiru 2018 LPLR 45374 CA. 4. It is a useful way to know the history of the property and how the vendor came to be vested with the property in question. If the operative part is clear, there will be no resort to the recital. In ex parte Davis, it was held that the specific description in the operative part of a deed is not controlled by a general description in the recital. A recital cannot be used to modify clear provisions of a deed. It is not every agreement that has a recital. There are some simple agreements that need no recital. Leases generally do not need recital except a sublease. 2. The operative part. It includes A. The testator, a formal statement commencing the operative part. Either now this deed witnesses as follows or This deed witnesses as follows. B. Consideration clause. When contract involves the consideration, it should be stated. The total amount of consideration must be stated in order to know how much is to be paid as stamp duties. The absence of consideration or consideration clause will not affect the validity of a deed because the deed derives validity from its form and not from the presence or absence of consideration. However, when inserted, the consideration clause performs the following functions and is important for the following reasons. 1. It is in the operative part that the interest is actually transferred from the grantor to the grantee or from the lessor to the lessee. It is the engine room of the deed. 2. It is evidence that the conveyance is not a gift. 3. It implies that the receipt will be issued to cover the amount received as consideration. 4. It is used for the assessment of stamp duties ad valorem, e.g., in consideration of the sum of dash paid by the assignee to the assignor. C. The receipt clause. This is added to the statement of consideration and evidences that the vendor acknowledges reception of the consideration. The receipt clause should be in bracket. It is usually drafted as follows. The receipt of which the vendor assignor acknowledges. Functions of the receipt clause. It is an evidence of payment of consideration. 1. 2. By Section 54 of the Conveyancing Act and Section 92 of the Property and Conveyancing Law, the inclusion of a receipt clause in a deed dispenses with the need to issue a formal receipt of payment. This is because it is a sufficient discharge between the vendor assignor and the purchaser assignee without any further receipt for same being issued. 3. By Section 55 of the Conveyancing Act and Section 93 of the Property and Conveyancing Law, the inclusion of a receipt clause in a deed is sufficient evidence of payment of the whole amount in favor of a subsequent purchaser, not having noticed whether the consideration acknowledged to be received was in fact paid or given. 4. By Section 56 of the Conveyancing Act and Section 94 of the Property and Conveyancing Law, the inclusion of the receipt clause in a deed is sufficient authority to pay money to the vendor solicitor upon production of a deed that was executed by the person entitled to issue the receipt, i.e. the vendor, without the solicitor producing any other direction or authority from the vendor, and there is no liability for loss. The receipt clause is not conclusive evidence that consideration has in fact been paid. Therefore, oral extrinsic evidence is admissible to show that consideration has not been paid or fully paid. The capacity clause. The covenant of title in a deed are implied by into the deed by status, and the vendor's assignor's capacity is what determines the types of covenants of title that will be implied. The capacity of the vendor assignor is stated immediately after the receipt clause. The vendor assignor may be expressed to assign either as beneficial owner, personal representative, settlor, trustee, or mortgagee. When the vendor assignor is expressed to have conveyed in his capacity as beneficial owner, the covenants of title implied by Section 7A and B of the Conveyancing Act and Section 100 sub 1A and B of Property and Conveyancing Law are: 1. Right to convey. That the vendor assignor has the right to convey the unexpired residue of his interest in the property to the purchaser assignee. 2. Quiet enjoyment. That the vendor assignor grants quiet possession and enjoyment to the purchaser assignee. 3. Freedom from encumbrances. That the property is free from encumbrances other than those disclosed to the purchaser in the contract or at the time of the contract. 4. Further assurances. Where it is a sublease, then in addition to the 4 covenants above, the following 2 covenants are added to make it 6. 5. The lease is valid and subsisting. 6. That the rent has been paid and all the covenants contained in the lease to be observed and performed have been observed and performed up to date. The above can be expressly excluded by the parties, inserting an appropriate clause in the deed. Words of grant. This depends on the nature of the transaction. Assignment, assigned. Mortgage, mortgages. Lease, leases. Parcel clause. This clause gives a detailed description of the property which is the subject matter of the deed. It is drafted as follows: all that property, piece of land, 3-bedroom bungalow, a dash, covered by CO number dash, dated dash, and registered at dash in the Lands Registry Office, Lagos State, together with all the rights meant and things appertaining to it, and more particularly delineated with the red badge line in the annex survey plan dated and prepared by dash. G. Addendum. It is used to define the estate taken by the other party or the quantum of interest given. That is, the addendum is a clause in a deed that defines the quantum or extent of interest granted to the purchaser or lessee under the deed. In Stephen Indugbo and Aneni 2003, it was held that the addendum is a clause in a deed that defines the extent of ownership in a thing granted to be held and enjoyed by the grantee. The addendum clause is found in deeds of assignment and in deeds of leases. In deed of assignment, it is drafted as follows: to hold same onto the assignee purchaser for a term unexpired on the said year of free of all encumbrances and subject to the provisions of the Land Use Act Cap L1 LFN 2004. It is in a lease. It is drafted as follows: to hold on to the lessee for the term of dash years commencing on dash 3 of dash 20 dash ending on dash 3 of dash 20 dash. In an assignment, the assignor conveys the entire residue of his interest in the property to the purchaser, while in a lease, the lessor retains some reversionary interest. Therefore, the absence of the addendum in a deed of assignment does not affect the validity of the deed, because it is implied that the vendor assignor is assigning all the unexpired residue of his interest in the property to the purchaser assignee. However, in a deed of lease, the absence of the addendum will convert the lease to an assignment. This is because the deed of lease must specify the duration of the lease by providing for the term and commencement date and the date it ends. See UB and Tejumola and Sons, 1988, 1 LRLR, Volume 1, at page 109, Odutola and Papers Act, Nigeria Limited, 2007, Operation Weekly Law Report 1214 at 1218. Thus, a deed of lease must contain the addendum. 3. Miscellaneous part. It includes a indemnity clause. This is an undertaking by the purchaser to pay the rent and observe all covenants and conditions running the land or property. The purchaser undertakes to indemnify the vendor in the event of a breach of the above covenants and conditions. A vendor may also undertake to indemnify the purchaser for any defect that may arise in respect of his title. The covenant for indemnity is drafted as follows: the purchaser assignee or any person deriving title under him covenants with the vendor assignor from now on to pay to the relevant authority all rents accruing to the title and due under the CFO for which the land is conveyed, and to perform all the covenants and conditions contained to be observed and performed by the vendor assignor, and also to keep the vendor assignor indemnified against all proceedings, costs, claims, and expenses on account of any omission to pay rent or to observe and perform any of the covenants and conditions. On the question of whether or not the indemnity clause must be expressly provided for in the deed, it will depend on the law where the property is located. Thus, in states governed by property and conveyancing law by virtue of section 101 on part VII of second schedule to the PCL, where the conveyance is for valuable consideration, the indemnity clause is automatically implied into the deed. In states governed by Conveyancing Act, the indemnity clause must be expressly provided for as cannot be implied. In states governed by Registration of Titles Law, as section 29 of the RTL, the indemnity clause is implied into the deed, whether it is for valuable consideration or not. Hence, the indemnity clause is only required if property is in eastern and northern Nigeria. It is not required under the RTL by virtue of section 129 RTL, and it is not required under PCL if consideration is paid. See section 101 of the PCL. This is an undertaking by the assignee to pay the rate and observe the covenants and conditions stated in the certificate of occupancy. B. Acknowledgement for production and undertaking for custody. An assignor can keep the original title documents when all the interest in the property has not been transferred to the assignee. In those circumstances, the interest of the assignee may be protected in any of the following ways: 1. Making an undertaking to keep the original title document in safe custody. 2. Acknowledgement of right of the assignee to the production of the original title document. 3. Endorsement in writing on the face of the original title document that a part of the land has been transferred to the assignee to put a third party on notice. See exception and reservation clause. Exceptions refer to whatever is withheld from the purchaser in the ground by the vendor, while reservations are new rights created by the party which are beneficial to the vendor. For concluding part, this includes A. The testimonium. Testimonium commences the concluding part of the deed, and it is drafted as follows: in witness of which the parties have executed the deed in the manner below the DIFS above written. B. The schedule, if any. It provides additional information and clarity and serves to banish technicality. The survey plan will be in the schedule. C. Execution clause. The deed must be signed, sealed, and delivered. Where it is a company, the signed, sealed, and delivered is replaced with the common seal of Nigeria Limited was affixed to this deed, and it was duly delivered in the presence of director and director secretary. A deed must be signed by the parties. Section 97 sub 1 of the PCL provides that where an individual executes a deed, he shall either sign or place his mark on it, and see alone shall not be deemed sufficient. See also section 83 sub 4 of the Evidence Act, Faro Bodley Company Limited and Osuji 2002, 1 Nigerian Regular Report, part 748 at page 316. Adi Farasin and Direct 2007, 11 Nigerian Regular Report, part 1044 at page 89, where it was held that if it is not signed, the document must retain its status as a wordless document. Signature can be marked and thumbprint. A party to a deed who fails to sign cannot sue on the contract covered by the deed. Prior to now, a deed must be sealed by individuals. However, what the courts now look out for is the intention to seal, and have they emphasized the need for actual sealing. Any indication of our intention to seal will be accepted for the purpose of due execution of it, and indeed will be deemed to have been validly executed, even though there is no actual seal on it. In First National Securities Limited and Jones 1978 to All England Report 221 at page 228, the deed was sealed, and the court held that where there is intention to seal, it must be upheld. Further, section 159 of the evidence have presumed that a deed which has been signed and duly attested to is presumed to have been sealed and delivered, even though no impression of the seal appears on it. It says section 159 provides that when any document purporting to be and stamped as a deed appears or is proven to be or to have been assigned and duly attested to, then it is presumed to have been sealed and delivered, although no impression of the seal appears on it. See also Strom, Deal and Ball in 1952 1CH 223. However, for a company, there must be actual sealing in the presence of a director and secretary of the company. There must be actual sealing and no presumption or intention of sealing from companies and corporations only. Section 160 of the Evidence Act 2011 and Section 98 sub 1 of the PCLB provide that a deed shall be deemed to have been duly executed by a company or corporation if its seal is affixed in the presence of and attested to by its clerk, secretary, director, or other principal officers or its deputy. See Western Nigerian Finance Company Limited and West Coast Builders 1971 1 UILR at page 93. Delivery does not necessarily mean physical handing over of the document. The fact that there was a handover does not mean that there is delivery, and absence of handover does not mean that there is no delivery. Hence, delivery means that the maker of a deed expressly or impliedly acknowledges his intention to be immediately and unconditionally bound by the terms of the deed. It is an act done to evince an intention to be bound by the terms of the deed. See Jegede and Citycon Nigeria Limited 2001 4 Nigerian Regular Report Part 702 at page 112. Vicent and Primo Enterprises 1969 2QB 629. Mere physical handing over or delivery without an intention to be bound does not amount to delivery for this purpose. See Awoju Light Industries Limited and Chinukwe 1995 4 Nigerian Regular Report Part 390 at page 379. Delivery can be total unconditional or conditional escrow delivery. Delivery in escrow means that delivery of the deed is conditional on the happening of some specified event or the performance of certain conditions, and delivery is not complete until the event has occurred or the condition has been performed. Interest will not pass until such conditions are fulfilled. Where a deed is delivered in escrow, the principle of relation back applies. This is a principle whereby an act relates back to a period date from which date it is construed to have taken effect. This means that where it is delivered in escrow, the effective date of delivery relates back to the day on which the deed was delivered in escrow and not the date on which the conditions were performed. See Alan Estates Limited and WG Stores Limited 1981 3 WLR 892. However, where it is delivered on the conditions that it becomes operative on the death of the grantor, it is not in escrow but a testamentary instrument. See Governor and Guardians of Folding Hospital and Crane 1911 2KB. Also, a deed which is delivered subject to condition and subject to such a right of withdrawal is not an escrow but merely an undelivered deed. The delivery of a deed in escrow is a final delivery in the sense that it cannot be withdrawn by the grantor before the grantee has had the opportunity to fulfill the condition. See Beasley and Hollywood Estate Limited 1961 CH 105, where it was held that if you deliver a document as an escrow, it is your act and deed and it is not recallable by you.